Now, in opening, I'd like to call upon Justice Tokura Saburo of the Japan Supreme Court to say a few words on behalf of the organizers.
On behalf of the organizers, I'd like to say a few words of greetings to all of you. This symposium has been held since 2017 in cooperation with 6 Japanese organizations in the field of IP dispute resolution in Japan, namely the Supreme Court, the Intellectual Property High Court, the Ministry of Justice, the Japan Patent Office, the Japan Federation of Bar Associations, and Lawyers of Intellectual Property Network Japan, and has now reached its 5th anniversary. Since 2017, the symposium has been held with the alternate participation of practitioners from the Asia-Pacific region and Europe and United States. However, due to COVID-19 pandemic, we decided to hold this year's symposium in the form of a web conference as in the previous year. Although it is regrettable that we were not able to invite overseas experts to Japan for direct exchange, I would like to express my sincere gratitude to more than 20 experts in the field of IP from more than 10 countries in Asia for their participation in this symposium. As you are fully aware, the world of intellectual property has become global quite rapidly, and in the field of judiciary, from the viewpoint of international harmonization, it is increasingly important to cooperate with other countries to properly get a hold of international trends and issues, and to deepen knowledge and understanding of each country's legal system and trial management. This importance remains unchanged even today, when the traffic of people across national borders is becoming more and more difficult. In the Asian region, in particular, I understand that against the backdrop of remarkable economic growth, various efforts are being made for the establishment of IP-related laws and for the realization of appropriate dispute resolution. In Japan, as part of the judicial system reform that started about 2 decades ago, we have been promoting reforms such as the establishment of the Intellectual Property High Court in order to reinforce the dispute resolution function for IP litigation. With the establishment of the IP High Court, international exchanges, including this symposium, have become more active. We hope to learn a lot from the discussions with practitioners in the Asian region who are trying to improve the IP judiciary, and at the same time, we hope you to learn more about the systems and operations in Japan. Through such mutual understanding, we hope that the judicial cooperation among Asian countries with close regional ties will become even stronger. In light of these circumstances, the theme of this year's symposium is IP Dispute Resolution in Asia. I believe that this symposium and other efforts for the internationalization of the IP judiciary will be a great stimulus for other areas of the judiciary as well. In today's program organized by the court, a mock trial will be presented by the Japanese side, followed by a panel discussion on the theme of international comparison of indirect infringement of patent rights. In addition, we are planning to have a panel discussion on the theme of use of expert knowledge, which is a common area of interest in several cases, and introduce the actual situation in each country. There will be more interesting topics to be discussed tomorrow and onward. Wishing for a fruitful symposium, limited time notwithstanding, I'd like to conclude my remarks.
Thank you, Supreme Court Justice Tokura, for the words of greeting.